And welcome to our Domestic and Family Violence and Centrelink Community Worker Training webinar. I would like to begin with an acknowledgement of country. We at Welfare Rights Centre acknowledge the traditional owners of the land on which we are today, the Gadigal of the Eora Nation, and pay respects to elders past and present. We respect that this land always was and always will be Aboriginal land. We're going to do some housekeeping. So you should have received a copy of the slides this morning if you registered for this session through our website. They're also available in the chat right now. You just scroll up to the top. Please write any questions you have regarding the content in the chat box. We'll be stopping several times to answer the questions. We may not be able to answer all of them posed today due to time constraints. Please keep your questions broad as we cannot give out any legal advice today, and questions regarding very specific situations will not be answered. When writing your questions, please be clear as to which payment you are referring to, just to make it easier for us. We'll be adding links to relevant information into the chat throughout the session, and there will be a 5-minute break about halfway through to allow you to stretch your legs. So we're going to introduce Welfare Rights Centre. Welfare Rights Centre is a community legal centre specialising in social security and family assistance law. We provide information, referrals, and legal representation to thousands of New South Wales residents each year who have a problem with Centrelink. So my name is Bree, and I am the Welfare Rights Centre's Events and Communications Officer. I am joined this afternoon by our Senior Solicitor, Donna Flood, and Alentia Weldon Oti, who is our First Nations Access Officer. Our peak body is Economic Justice Australia, who we work with to advocate for law reform. So just to reiterate, today's presentation is general information only. It is not legal advice. Clients should obtain legal advice about their individual circumstances. When you're writing questions in the chat first, please keep them broad. We can't give out legal advice. So now I'm going to hand it over to Donna.
Hi everyone, and welcome to our session. I'm hoping that you will find it helpful and useful. We're not expecting you to become social security solicitors after this, but we are hoping that by listening to this session, you might be aware of situations where you might need to get some further advice for your clients, or you might become aware of issues that you may not have been aware of before. So these are the issues, these are the different topics that we're going to be covering today. There's quite a few. It's a really long session. But you do have the slides in front of you, so you don't need to write down absolutely everything that I say. So we're looking at members of a couple, care of children, when there's issues with who has care and where the children are, issues to do with family tax benefit and child support, crisis payments, when you're helping someone who's a newly arrived resident, issues with special benefit debts, and the whole appeals process. So we thought we'd start with a poll, and we were wondering if you would be able to let us know what the main issues are that you see in relation to family and domestic violence in your work, especially when it's associated with the Centrelink payment.
So you can put in more than one answer as well. So I'll just give it another minute. Okay, so I'll just end it now. Got almost 80% of people have answered. So people are still answering. Okay, I'll end it
I
now.
think we're good now. Yeah.
I'll let you go, Donna.
Yeah. All right. So just so that um, for people who might be interested, can you see the results there? Have I shared them?
Oh, I'm sorry. So I'll just go ahead and read out.
Okay.
Essentially, the biggest problem that people have noted here is unable to leave a violent relationship due to a lack of financial support.
Yeah.
The second most popular answer was problems providing evidence or paperwork. And the third was challenges accessing a Centrelink social worker, which is always a popular answer.
So there's been some changes to the way that Centrelink operate in the hopes that it will provide more support for people who are trying to leave a relationship and needing financial support. So we will touch on that later on. Hopefully that will help in some way. All right, so we'll keep going. So family and domestic violence and Centrelink. So the way that Centrelink defined family and domestic violence is critical. It has changed over recent years in response to some of the work that our peak body Economic Justice Australia has done. And it's really important to understand exactly how it's defined when you're dealing with Centrelink. So it does cover the coercive, threatening, dominating, controlling, and abusive behaviour. It does look at people more than just the people in an intimate partner relationship. So it recognises that relatives, guardians, kinship groups, and other family groups can have that domestic and family violent aspect to the relationship. It also recognised that carers and support workers can be the perpetrators of domestic and family violence, that there's also current and former friends. But one of the really important things to look at is that it's now very, very clearly and explicitly stated that economic and financial abuse, including withdrawing, withholding and controlling someone's money, like their Centrelink payment, is actually formally recognised in the definition of domestic and family violence. So some of the common issues that we see when people are experiencing domestic and family violence and with regards to Centrelink is that one of the ones that everyone here said was most common was that unable to leave a relationship because they don't have access to that Centrelink payment. They might have a reduced rate of payment because of of being in a relationship, but they get no financial support from the perpetrator. They might be ineligible for a payment because of the perpetrator's income and assets. There could be people, the perpetrators might be forcing non-reporting to Centrelink or hiding income from the person applying for a Centrelink payment. The issues with who has the care of kids and changes to the care of children can mean that there's incorrect payments being paid, and that the perpetrator falsely reporting that they have the care of kids to Centrelink or removing the kids from the person who previously had primary care without consent can also impact Centrelink payments. You can ask Centrelink for a social worker to contact the client whenever there's family and domestic violence and when there's any of these sorts of issues, in the hopes that that might help clear up problems within Centrelink and the issues with the payment. So, big one is member of a couple. So when you're a member of a couple, it has a big impact on your Centrelink payment in a lot of circumstances. It can impact whether you get a payment, and it can impact what rate of payment you get, whether you get a single rate or a coupled rate. It also impacts whose income and assets are being used to assess how much payment you might be eligible for. Because when you're in a relationship, the other parties or the partner's income and assets are also used in the assessment of your rate. And being in a relationship or being a member of a couple often intersects with family and domestic violence and Centrelink. People's relationships aren't declared. They can be coerced into not declaring a relationship. The perpetrators can hide income and assets. They can refuse to disclose income and assets. Someone can be paid that lower partnered rate, but the perpetrator doesn't actually provide any financial support. They're not getting that financial benefit from being in the relationship. Money is stolen. Relationships are just complicated. People don't actually know whether they're in a relationship or not for Centrelink purposes. And it can be really unclear what's going on and whether you're in a relationship or not, and when you should be talking to Centrelink and when you should be reporting to Centrelink. So, how does Centrelink define relationships and when you're in a member of a couple? It's subjective. It's not really clear. It's very much on a balance of weighing up all the different factors and all the different facts, but they look at 5 different broad areas. They look at that financial aspect, who's providing financial support, what the finances are within the relationship. They look at the nature of the household, who's doing the domestic work, are they cooking for each other? Are they cleaning for each other? Are they, watching TV together? Are they spending time together? They look at the social aspects of the relationship. Do they visit each other's families? Do they go out together? Do they socialise together? Do their friends believe they're in a relationship? Do family believe they're in a relationship? Um, the sexual relationship is only one small part of it. It's not the be all and end all. So, yes, they want to know whether they share a bed. Yes, it's important and relevant whether they're in a sexual relationship, but actually, it's not the defining part of it. And they look at the people's commitment to each other. Are they committed to each other? If something was to happen, would they be, supporting them? Is this a long-term thing that's happening between these people? Um, you know, are they the focus of each other's commitment to each other? It is subjective. It's looking at all the facts, and people's relationships don't tick every box on one side or the other. And it's social workers that can make the decision, and it's Centrelink officers that can make a decision. So there's a really useful fact sheet on the Economic Justice Australia website, and it goes through each of those 5 different aspects of how Centrelink define a relationship. And it includes all of the questions that Centrelink officers have a tendency to ask your clients when they are trying to work out whether you're in a relationship or not. So they're looking at, do you have joint bank accounts? Do you have access to each other's bank accounts? Do you manage your own finances? Do you lend and give each other money? Yeah. And you'll find when talking to your clients that these are the actual questions that Centrelink officers are asking. So, me as a lawyer, I find it incredibly helpful to have this fact sheet open in front of me when I'm talking to my clients to try and work out whether they're in a relationship or not. So, you might find this fact sheet quite helpful yourselves as well. One of the really important things to remember, though, and this has become far more emphasised in the last few years, it's a lot more recognised now, is that the presence of family and domestic violence. There is a relationship, there is also family and domestic violence, then that family and domestic violence may indicate that actually there isn't a relationship at all. That even if looking at those questions and looking at those categories, there's some things in there that indicate that it's possible that a relationship exists. The fact that there's family and domestic violence may indicate that it's actually not a true relationship, that there really isn't actually, they're not actually members of a couple. So collecting evidence of that family and domestic violence, evidence of the AVOs or police reports or other things, and also asking for a Centrelink social worker can be incredibly helpful in showing that a relationship does not actually exist, even when they're possibly ticking some boxes on the side that it does. So we've got a couple of case studies going through this session for you that we hope might be helpful.
Hi, Maria. My name's Daniel. I'm calling from the Welfare Rights Centre. How are you today?
Good, thanks. How are you?
I'm well, thank you. So I understand you've got a parenting payment debt. Can you tell me about that?
Yeah, it's a huge amount, about 43,000.
Wow. And what's the? I've seen the letter that you've provided to us, and it says it's for the period 2018 to 2020. Why does Centrelink say that you weren't eligible for parenting payment?
They say I wasn't single for the 3 years after I separated from my husband.
And do you know why they might think that?
Yeah, it's a real big mess, really. I shouldn't have married him in the first place, but I was under a lot of pressure from my family. Our family said we were a good match. And, our culture is very strict. So I was 18. I barely knew him. I didn't spend time with him before we were married. So how would I know what he was like?
Yeah. And what was he like?
Well, now I can see he was horrible from the start, but I just kept getting sucked back in.
Can you explain what happened?
Well, straight away when we got married, if I didn't look after his mother right, he'd get angry. And I knew he was seeing other women because I found texts and horrible photos on his phone. He's a player, basically.
Yeah. And was he ever violent?
Yeah, he was. And it got quite bad. And even though I had to call the police twice, he wouldn't stop coming. So finally, when I was 4 months pregnant, he moved all his things out, and I didn't see him until the baby was born.
Okay. You said police were involved. Did they ever issue any AVOs?
Yeah, I've had 2 AVOs, but they've both run out, and I don't have any more.
Okay. How were you supporting yourself?
Well, I used my savings, and then I applied for parenting payment.
Okay. At the single rate?
Yes, and then when the baby was about 6 months, he started pushing to get back together, and I didn't want to. So but my family got involved. So I finally agreed to go on a holiday to Bali, but it was terrible because I wouldn't sleep with him, and I came home early, and I didn't let him move back in.
Okay. So was he paying you child support?
Yeah, he was, but through the tax. So because he was single on his tax, so I moved into this duplex with my dad in the other half.
Okay. And did you pay rent?
No, we'd bought half of it when we got married with my dad.
Okay. Whose name was on the title?
My dad's name was on one, but my ex and my name on the other one.
Okay.
And actually that's when I started seeing someone else, but unfortunately one night when my ex came over for my son's birthday, I slept with him and I got pregnant. It was so stupid, just he was being so nice, and I don't know, so I broke up with my boyfriend, and then of course our parents were saying you have to get back together now, and he had a girlfriend, so they were saying you can't let this other woman raise your children, which actually really scared me, and eventually I agreed to sell the place I was living in and buy a bigger place with him.
And did you go ahead? You said you bought a bigger place?
We did. The accountant said to buy it in joint names because it's easy to get one name off, but basically he kept seeing his girlfriend, so I just moved in by myself. He's actually never lived there, and that's it basically. I haven't lived with him for more than 3 years, but the paperwork looks like this. And of course I have my daughter, so it just looks really bad.
Yeah, I understand. Well, we'll just break a couple of those issues down one by one and discuss them in a little more detail.
So thinking back to those 5 aspects that Centrelink look at, and listening to that story and watching that story, when you're looking at whether deciding if she is separated, that they're not in a relationship, and you look at the financial aspects, she's single on her tax return, she's getting child support, and there's no other financial support or connection between them. That financial support between them. They haven't lived together since that parenting payment single claim. There's 2 AVOs, before the separation. The family know that they've separated. He's had other partners. She's had other partners. and the family holiday, that Bali holiday, ended early, then they declare that commitment to each other, they declare themselves single, they live separately, they don't help each other, and there is no support from the ex at all outside of that basic child support. So there's quite a few things there on the side of, no, there's no relationship. But when you look at it from Centrelink's perspective, there is things in support of the fact that they're in a relationship. So you can see why they were questioning it, because they purchased a property together well after that separation. They went to Bali on a holiday together well after the separation. And they also conceived and had a second child, another child, well after the separation and after the debt period started. So there's things balancing on either side, and you can see why Centrelink looking in might believe that there is a relationship, but you've got to look at the whole picture, and you've got to gather evidence supporting the whole picture. So you might have clients that are in a slightly different situation where they're in a relationship but they've separated, but they're actually still living together. And it is possible to complete a form, which is linked at the bottom there, saying that you're separated but living under the one roof. So that when people are living in the same house but they've decided to separate it, and they've actually acted on it. You can't just think about it, maybe I will, you've got to act on it. But you also have to explain why you're still living together even when you're separated. You've got to show evidence of that relationship breakdown. You've got to show evidence that you're separated, and you've got to show evidence that you're not planning to get back together. But you can also talk to Centrelink if there is a family and domestic violence aspect, and that Centrelink social worker will do an assessment and make a recommendation to the Centrelink officers about whether they believe you're separated under the one roof or not. And if you've said that there's family and domestic violence, then the perpetrator shouldn't be interviewed and they shouldn't be involved in that decision. So the thing to remember, though, that is if you are considered separated under the one roof, Centrelink will come back and will check that you still are. And they will do regular reviews. And if you remain living together, declaring yourself separated, they could change their mind at any time. They could decide, actually, no, we believe that your relationship has now resumed, or we believe that now you are actually a member of a couple. That decision can be backdated, but it usually isn't. It can lead to debts. Okay. So this is one of these really helpful things that has changed recently in regards to how Centrelink treat people who are experiencing family and domestic violence. And it's one of the really useful things for people who find that they don't have access to payments because of their partner's income and assets, and can't leave relationships because of that family and domestic violence and that lack of financial support. It's the only time pretty much in social security law at all that the section in the legislation is used to name what a thing is, and it's called Section 24. And it's quite odd to be saying Section 24 when you're talking about social security law, but we are. And essentially what it is Centrelink is able to go, these people are in a relationship. They are in a relationship, the relationship exists. We're not going to decide the relationship doesn't exist at all because of domestic violence. No. This is a relationship. They are members of a couple, but for the purposes of Social Security, we're going to behave as though they are single. So we recognise and accept that the relationship exists, but because of the family and domestic violence, we're going to pretend it doesn't, and we're going to behave as though it doesn't. So it means that a person is treated as single instead of in a relationship, and they may then have access to payments like that they would otherwise not have access to before the relationship actually officially ends. So your clients may be able to apply for family tax benefit, parenting payment single, and payments that they might need in order to be able to leave the house and leave the relationship before the relationship's actually over. It's can be quite a complicated one to run. You do need to contact Centrelink and say, I'd like to apply for a Section 24. And it can be complicated and difficult to run. So if you need advocacy, if you need to talk to a lawyer and get some help, contact us for advice or contact one of the other members of Economic Justice Australia, because there's members all over the country. In every state in Australia, there's people that specialise in social security law, and you just need to go to Economic Justice Australia's website to get their details. So this is our first spot to answer questions. We will be stopping a number of times throughout. So maybe Bree, if there's any questions that anyone has, feel free to ask.
Okay, so the first question we have is from Deborah. She would like to know if there is a timeline for S24. Do they need to have left or exited the relationship within a time frame, or do they otherwise incur debt?
Look, that one I can't answer off the top of my head. I'm so sorry. What I would be doing if you're applying for it on behalf of a client, I would be asking at the time. So it's not a form that you can download. You do have to talk to Centrelink to ask for Section 24 to be considered. So you'll have that opportunity to talk to them and ask.
Okay, so there's another question also about Section 24. Is it relevant if one member of a couple is incarcerated?
So Section 24 can be used in all sorts of different situations and not just for when there's family and domestic violence. And so you might find that if someone is unable to be financially supported by their partner for some reason, and being incarcerated could be one of them, that might be a situation where you can ask for Section 24 to be considered.
Okay, there's one more question at the moment. What is the role of Centrelink social workers in DV cases?
You're going to find that they're mentioned a lot throughout our session today. They are constantly being talked about because they're often the ones that are making those assessments and giving recommendations to the Centrelink officers that make the decisions, and saying whether they believe that the domestic violence exists or all sorts of other things. So they not only will do referrals and recommendations for organisations that you can access for support that, social workers will do, and providing supports in that kind of way, but they also write reports and make recommendations to the people making the decisions. Okay, all right.
There's one more question, if that's right. I know that this is coming up later. They're asking, how do we get in contact with a Centrelink social worker?
Look, we've got some slides right at the end where we talk about that.
Yeah, sorry.
No, that's okay. Okay, so our next section of this session is all about care of children, when there's children involved in the relationship and how the care of the children can impact your Centrelink payments. Look, this is quite a technical area of the session. It can be there's a lot of different ways where your Centrelink payments are impacted. And so we'll make our way through it. So you've got where there's disputes about how often each parent has with the child. You've got situations where one of the parents might be unable temporarily to care for a child. You've got situations where the child may be abducted or hasn't been returned after a visit with the other parents. There's informal arrangements and informal care arrangements that can impact your Centrelink payment. And there's issues with child support when you're not actually getting the child support that you have been assessed at, or where it's not safe for you to try and get it. And child support does impact your Centrelink payments as well. So different payments have different ways of being assessed and different things going on. So if you are getting the family tax benefit, the payment can be split between the two people that have care of the child. So as long as you have 35% care of the child, you are eligible for 35% of the family tax benefit. Okay? And it all entirely depends on how much time the child is spending with you each week or each fortnight, as to whether you have the child enough to be eligible for that percentage of family tax benefit. But the income support payments, so parenting payment, youth allowance, job seeker payment, and special benefit, cannot be split between parents. Only one parent is able to get those income support payments. So when you're looking at the family tax benefit, you're looking at who is the primary carer. You're looking at who is the person who's got the greater responsibility, who's making those daily decisions, who's looking after the child's needs, who's taking them to appointments, making the appointments, taking the kids to school, all of those mundane day-to-day decisions, who's doing them, and whoever it is the one that's going to be considered the primary carer. Now, for parenting payment, what they're looking for there is who is the principal carer. And that's a far more legal viewpoint. It is who has legal responsibility for the child, who is providing that day-to-day care, welfare and development, and making those legal decisions about the care of the child. So if there is disagreement about who the care arrangements, the people are going to have to argue their case to Centrelink. And court orders aren't enough, because court orders might exist to say you need to be providing, the care needs to be divided in this way, but that's not what's relevant. It's where the child actually is and what the actual childcare arrangements and who is actually providing the care that's important. So when you're looking at percentage of care, it's incredibly important to update Centrelink with changes as they happen. You must update within 14 days of any change happening, because otherwise you risk a debt, because you risk being paid payments that you're not eligible for. So in this particular situation, we had someone who left a violent relationship and took the children with her, but the ex was constantly demanding changes to the days and additional days, and forcing her, and during mediation and other times was threatening her to stop paying child support unless he got more time with the children. She was constantly updating Centrelink and tried desperately and thought she had actually updated them accurately as she went along, but she ended up getting a $17,000 debt. So Centrelink believed that she had them significantly more than she actually ended up doing, and she was well and truly overpaid. So even if you think you're updating them, you might not be updating them within 14 days, you might not be updating them enough. You've got to keep them up to date with the changes. So it is possible to retain payment for a period of time, even when you're not actually caring for the children as Centrelink believe you might be. So if there is a formal care arrangement, there might be a mediated agreement or court orders, and one of the parents departs from that formal arrangement without consent, so they force getting extra days without consent. The child might change from one party to the other without consent. It might have been sole care from one parent, but it becomes shared care, but there's no consent. If you have told Centrelink within 14 days what has happened, and you have told them that there was no consent and that you are taking reasonable steps to get the care back to that formal care arrangement and you're showing evidence of having taken those reasonable steps, then you may be able to be paid your Centrelink payment for a period of time, even when you're being paid on the formal care arrangements and that's not actually what's happening. Okay. Now, this isn't when a child is abducted and taken and is missing or is not necessarily in a location that's unknown. Okay. And it's different to a situation where the perpetrator lies to Centrelink. You know, this is where there's that formal arrangement, but there's been a departure from that formal arrangement without consent, and you're trying to get back to it. But you must update Centrelink within 14 days, because if you don't, then this can't be happening and you may be at risk of a debt. Okay. So if a child is removed or abducted without consent, then you also can continue to receive your Centrelink payments for a period of time, as long as you've told Centrelink within 14 days and you're taking reasonable steps to recover the child. So you've reported it to the police. You might have taken out recovery orders through the courts. You might be seeking family law advice. You might have gone to legal aid, gone to a family law lawyer, gone to a community legal centre. And you are doing everything you can in order to get that child or those children returned to you, and you are showing Centrelink and providing this evidence to Centrelink, then you can get your payments for a period of time. And each payment, it's a different period of time. So I'm not going to tell you exactly how long you can get the payments for, because it gets a bit too complicated. It's a situation by situation, payment by payment sort of thing. So Centrelink, even if the other party claims a Centrelink payment for the care they're providing the children, Centrelink shouldn't grant it as long as that person who was principal carer is taking reasonable steps to get the child back. So if a payment's reduced or cancelled in this sort of situation, you contact us, contact a lawyer, contact a social security lawyer. But the thing is, once formal actions are taken, so maybe the child is removed by docs, there may be new family court orders or new consent orders, and it's formalised that care of the child has changed, then payment will stop. You will not be able to get a Centrelink payment at that point. So this was another situation where there was a custody dispute over the violence ex-partner. There were family law orders that the child lived with Jenny. Ex-partner left the state and took the child with him and refused to return to New South Wales and refused to return the child. So the ex-partner claimed a Centrelink payment, said he was the principal carer for the child, and Jenny's parenting payment single and her family tax benefit were stopped, and Jenny was left without any income at all. She was going through the courts trying to get a recovery order. Now, if she had told Centrelink within 14 days that her child had been taken and that she had gone to court and was trying to get recovery orders, then her payment might not have stopped. But because she didn't tell Centrelink, once he claimed, he got the payment and her payment was stopped. So really, really common situation is where the ex lies to Centrelink, and does a false dobbing, gives the wrong information. So if a perpetrator or the other parent gives information to Centrelink about the care of the children, Centrelink is supposed to be contacting the person who's receiving the payments before their payments are cancelled, to give them an opportunity to say, no, that's not what's happening. I have the care of the child, and look, here's the evidence to show it, Here's the information from the school showing that I'm dropping them off every day and picking them up every day. Here's the information for the childcare centre, doctors or whoever is around to show that I actually am the one with the care of the child. So it's that opportunity to either show that you have care of the children, or it's an opportunity to claim a different payment if the children have actually left your care. Once again, if payments are reduced or cancelled and you believe that was the incorrect decision, that Centrelink shouldn't have made that, you contact us or you contact one of the social security advocate centres around the country. Okay. So this is another time where social workers are making the assessment. You know, if two people are claiming the care of the child and both are saying that they're getting, opposed information, that the information's not agreeing with each other, then social workers are the ones that are looking at the evidence and talking to the parties and making that decision about who is the principal carer. So Centrelink say that they will contact the principal carer before a payment is cancelled, but they aren't always. Okay. So we hope that they will do it and we hope that they do it more, but it doesn't always happen. Okay, so if you temporarily don't have the children, but it's not that case of, the ex is taking the children for an extra day a week or an extra 3 days a week without your consent, or they have taken the children interstate without your consent, and not in that sort of a situation, but say maybe they've gone to stay with grandma or auntie for the holidays, or the principal carers had to go into hospital for a brief period of time, or there's some reason why the kids are just temporarily staying somewhere else, then it's possible in some of these situations that your payment can continue. And in these situations, your payment can continue for 8 weeks for parenting payment or 4 weeks for family tax benefit, as long as that absence has a defined end date. They're returning before school goes back. They're returning once you're discharged from hospital. Yeah. So as long as there's that defined end date, you can get payment for a period of time. And it's possible to extend that parenting payment for a period of time, but only in certain limited circumstances. And you must have that defined end date still.
Hi, everyone. So I'll be briefly talking about what is informal care for the purposes of retaining your family tax benefit payments. So you'll often see informal care situations arise when a parent has delegated the care of their child to another party. The other party could just be grandparents, relatives, or friends. So in informal care situations, who is eligible to receive the family tax benefit for the children depends on whether there has been a change of care or a delegation of care. Whether a change of care has occurred can be difficult to determine. It is a subjective decision, and in the next slide, we will look at the factors that Centrelink considers when determining if a change of care has occurred. So informal care generally starts off as a delegation of care. So you can see that a delegation of care is that the parent retains all responsibility for the child, including the ability to make major decisions. The parent should also be meeting most, if not all, of the financial cost of that child whilst in the care of the other person. The care arrangement should be temporary and short term, and that they should have a specified end date. A change of care is different to a delegation of care. So a change of care can happen when it is beyond short term, and the parent has a lower level of responsibility than that is required of a delegation of care. In a change of care, in which a delegation of care does change to a change of care, then the new carer would be entitled to receive family tax benefit, generally after 4 weeks from the date that the change of care had occurred. So in the next slide, we have a case study demonstrating what is considered a delegation of care. So Lisa is fleeing an abusive relationship and has moved from her home as she doesn't immediately have stable accommodation to go to. So she leaves her children with their grandparents. She is currently staying with friends. However, she has signed a new lease and will move into her property in 3 weeks' time, at which point she intends to regain care of her children. She still calls her children every day. She sends money to cover their expenses, and she retains all responsibility when it comes to making major decisions in relation to her children. So, just thinking back to the previous slide, so because Lisa sends money, she continues to make all major she continues to have all major responsibility over her children, and the stay with her grandparents has a specified end date. In this scenario, she would be able to retain her family tax benefit payments. So this one is a similar example that I just gave in the previous slide. However, following an abusive relationship, Lisa temporarily leaves her children with their grandparents, although she intends to have her children return to her once she finds stable accommodation. But because she has no specified end date, it may be considered a change of care, at which point the grandparents could actually apply for family tax benefit for those children.
So if you are, if you have children, then child support can also impact your Centrelink payment. It impacts your family tax benefit. So Centrelink require you to claim child support from the other parent if you are not living together, and the other parent is not, you're not in a relationship and caring for the children together. If you don't claim child support, if you don't get that other party to pay child support, then your family tax benefit is dropped from the top rate, or the standard rate, down to what's called the base rate, and that's thousands of dollars a year difference. So it's called seeking maintenance action. And if you don't seek maintenance action, you don't claim child support, you only get that base rate of family tax benefit. However, they recognise that actually claiming child support can be dangerous in some situations, and in other situations is impossible. So you can be exempt from seeking maintenance action. You can be exempt from seeking child support if there is a history of violence with the other parent, if you fear retaliation from seeking child support, if you can't find them, if you don't know their identity, or if there are cultural beliefs that mean that seeking child support is not appropriate. So once again, it's a decision that's made by a social worker, or in this case, it's also can be made by an Indigenous specialist officer. And you do once again need to provide evidence that for why you're seeking that exemption. But as soon as you seek that exemption and it's granted, then your family tax benefit is increased to the full rate, and it's based then on the income. It's an income tested payment. So even if you're exempt from seeking child support, if you receive some, if the ex ends up paying it, even though you haven't formally sought it, you do need to declare that to Centrelink, because child support is considered income, and family tax benefit is an income tested for family tax benefit purposes. Okay? Only for family tax benefit purposes, not for other purposes. Okay. So there's other situations where child support is a problem. So if you are in a situation where you've claimed child support, it's been assessed, you know how much you're meant to be getting, but it's not being paid, you'll find that some of your clients or some people, that child support is enough to bump them up higher in their family tax benefit income test, and their family tax benefit payment might be dropped because their income's too high. However, they're not actually receiving the income because they're not getting the child support that Centrelink believe they are. Okay, so the way that family tax benefit and the income from child support is normally assessed by Centrelink is what's called the entitlement method. So Centrelink will assess your income and your child support based on how much you're entitled to receive. They don't look at your bank account. Don't look at how much money you're actually getting. They look at how much you're entitled to get, and they will assess your family tax benefit income based on what you're entitled to get. If you're not getting what you're entitled to get, you can ask that your family tax benefit income is assessed on what's called the disbursement method, which is being assessed on what you get rather than what you're entitled to. So the only way that you can get this is if you are having your child support collected by the child support agency. So if you're on an ad hoc sort of collection, sort of, personal arrangements between you and the ex, you cannot request the disbursement method. The only way you can access the disbursement method is if the child support agency is collecting your child support but aren't able to. It's just not coming. Okay. So if there are any issues with the child support payment and the child support agency isn't able to collect what you're entitled to, then ask Centrelink to use that disbursement method, and then your income will be assessed only on what the agency is actually able to collect. Okay. Any questions before we have our break?
Hi. Yes, just bringing them up. Sorry. Juggling various screens. Okay, so what does Centrelink do if a false claim is made and found to be false the first time or multiple times?
So if someone is receiving, family tax benefit, parenting payment, and someone makes a claim for those payments saying that they have the care of the children, Centrelink investigates and goes, no, you don't have the care of the children, then no, there should be no impact to the payment whatsoever. Payment will just continue because Centrelink's realised that that was a false claim, and it will just continue. Okay. If for some reason the payment has been cancelled because of that false claim, and then you prove that it was a false claim, that you've always had the care of the children, you've appealed that decision to cancel the payment, because that's what your client needs to do. They need to appeal the decision to cancel the payment or change the payment. Then there's an investigation, discovery that that was actually a false claim. Then the person's payment is restored to where it should be, and any amount that they didn't receive should be paid back to the date that the payment was first cancelled or dropped, as long as they appealed the decision to cancel or change the payment within the limitation period, which is 13 weeks. So as long as they questioned and appealed it within 13 weeks, they should be back paid to the date that that decision was made to cancel or reduce the payment.
And I'm sorry if I missed this, but do Centrelink do anything to penalise or require evidence from the abuser in the future that has reported them?
I don't know.
No? Okay.
So, I mean, to make a decision on whether someone is paid a payment, they need to know that they're eligible for that payment. So, at all times, if a decision is being made about a payment, they need to know whether they're eligible for the payment.
If a perpetrator once received the family tax benefit, can the primary carer claim the whole family tax benefit back for themselves if there is a ADVO against the perpetrator?
The mere existence of an AVO or ADVO does not mean that someone is not eligible for a payment. It is who has the care of the children. Did they have the care of the children? Was it a disputed care situation where they were taken without consent and they're trying to get them back, or did they just have the care of the children? The mere existence of an ADVO isn't enough to say you should never get that. It's who's got care of the children. If a perpetrator has received the family tax benefit for a period of time but did not have the care of the children for that time at all, or didn't have the care that they stated they did, then the person who had the care can claim family tax benefit. And you can claim for past periods for family tax benefit. It's the only payment that you can claim for past periods. But you need to show and prove that you actually had care of the children at the time.
If a victim survivor is on a temporary visa and the perpetrator / their partner is a citizen, would S24 still be available to them on a temporary visa?
We're going to be talking about newly arrived residents and residency issues and things like that after the break. And I'd probably like to revisit that question after, just in case, because it might become clear.
Okay. If a court order regarding care isn't sufficient, how does someone prove what the actual care is and who the child is with?
So it's looking at that person's life and seeing what might be available. So it is, so maybe a letter from the GP. It might be stuff, if they're going to school, then it might be information from the teacher, information from the admin staff or stuff from the school about who's dropping the child off, who do they believe has care of the children. It could be, a stat deck or a statement from the neighbours, or from friends and relatives. It could be if there's social workers or carers and things like that who are working with the family, then it might be letters of support and things from them. It could be looking at, maybe you're constantly buying things or with the children and things like that. It might be, you might even be able to show transactions in bank accounts that might show it, or it's also whatever you can think of and whatever you've got that might be showing that, Opal cards showing that they're catching the bus from your neighbourhood to get to school rather than from the ex's neighbourhood to get to school. So Opal card records, things, all those sorts of things might be there to show who has care of the children.
So just do one more for this section. Yeah. What can Centrelink do if a perpetrator doesn't engage or cooperate with the child support claim agency?
So unfortunately, we can't do child support. We don't advise on child support. Legal Aid have a child support department. We will put their contact details or a link to the website to show you how to contact Legal Aid New South Wales Child Support. So if you're having issues with collecting child support and things like that, then it's Legal Aid that's the ones to chat to.
Okay. Actually, I'll just do one more.
Yeah.
What role can we have as DV caseworkers in supporting clients to prove DV to Centrelink?
So Centrelink accept letters, support letters from DV caseworkers as evidence of the existence of domestic violence.
Okay, so let's keep going with the webinar.
Cool. All right. So we'll take a 5-minute break. So it's now, well, we'll say it's 3 o'clock and we'll come back at 3:05. So we're nearly back. We'll just give people, a short while, and we'll start again. Okay, so welcome back, everyone. And we will move on. So one of the things that most people think about when they think about Centrelink and domestic and family violence is the crisis payment. So as we've already seen, there is a lot more to how domestic and family violence can impact your relationship with Centrelink and your payments from Centrelink. However, we will be talking about crisis payment because it's really important to know what your rights are. So crisis payment is an additional payment. It is not an advance on, or it's not part of your payment. It's an additional payment. It is equal to a single week of your primary income support payment. You cannot get crisis payment unless you are already on a Centrelink income support payment. So you have to already be on job seeker, parenting payment, youth allowance, special benefit. You must already be on a Centrelink payment, and you must also be in severe financial hardship. So if you're helping someone who's escaping violence, who hasn't been on a Centrelink payment or isn't on a Centrelink payment, they can claim that income support payment at the same time as they're claiming crisis payment. So pop in that application for parenting payment and crisis payment at the same time, so that when the parenting payment is approved, they'll also get that crisis payment. Okay? You don't need to wait until that primary payment, that parenting payment, job seeker, one of those is processed and approved before lodging an application for crisis payment. And actually, if you wait that long, it might be too late.
Hi, Donna. Sorry, your volume has gone a little bit lower.
Oh, I'm so
Letting
sorry,
you know.
everyone. My headset ran out of batteries during the break, and I was so pleased that it happened during the break and not. How's that? Is that a bit better?
It sounds the same. We might just have to
We will try
adjust
something
our volumes and
else.
just turn our volume up a little bit if you can.
Let's go with the audio settings here. How's that? Is that any better? Is that any better?
It's pretty much the same, but yeah, if everyone else could slightly turn up their volume, that might help. We apologize, technical difficulty. Okay,
really
it's louder. It's
that's
louder
better.
now.
Brilliant.
Yes.
I'm really sorry about that, everyone. As I was so pleased that it died during the break and not while I was actually talking to you. But all right. So if you are the people who are eligible for crisis payment are people who are victims of family and domestic violence, where that person has left home and isn't intending on returning, or where the perpetrator has been removed from the home and won't be returning. Crisis payment is also available for people who are recently homeless, who are recently released from prison, and who have recently arrived in Australia as refugees or humanitarian visa holders. So for the family and domestic violence aspect of that, you can do 4 applications in 12 months. Centrelink recognise that it can take multiple times before you have permanently left a relationship, so they will pay crisis payment 4 times in 12 months. Social workers do the assessments to make sure that they believe that you're eligible for it. So once again, social workers are involved. Okay. So the thing is that when you're talking to Centrelink and when you're making that claim, when something has happened and you think that crisis payment is something that you might be eligible for, you have to be really clear when you're talking to Centrelink that you're talking to them about crisis payment. You have to remember to mention it, because otherwise you might lose your ability to get it. So there's some really strict timelines and requirements for claiming crisis payment. For the people who are remaining in their home, but the perpetrator has been removed and is unable to return, then you have to contact Centrelink and you need to talk to them within 7 days of that perpetrator being removed. You need to not just contact them, you need to mention that you're contacting about crisis payment. Now, from the day that you contact Centrelink, you then have 14 days from that moment to lodge your claim for crisis payment. Okay. Now, to show that you're eligible, you have to show that the perpetrator cannot or will not be returning to the house. So, ADVOs, police reports, things like that or similar, statements from support workers, doctors, schools, the same sorts of things that I was talking about earlier, to show that the perpetrator has been removed and is not going to be returning or is unable to return. If you're in that situation or your clients are in that situation where they've had to leave the home and they're not returning to it because of family and domestic violence, then the timeline's a little bit different, because the 7 days to contact Centrelink doesn't start until the moment that they realise or decide that they're not returning. So you'll often find these situations where people will leave and they're just waiting for it all to calm down, and then they'll be able to go back, and it's okay. They'll go back and they're just going to crash with a mate for a couple of days and they'll go back, or they're in a refuge and they'll go back. And then they go, actually, no, I can't ever go back. This is it. I'm never going back. And it's that moment that they realise or decide that they're never going back. That's when the 7 days start. And they have 7 days to make contact with Centrelink from the moment they realise they're never going back or decide they can't go back, to contact Centrelink about crisis payment, remembering to say it's about crisis payment. And then they've got 14 days from the moment they contact in order to actually lodge the claim. So they have to show that they've left due to extreme circumstances, that it's unreasonable for them to return, and that they're intending on setting up and establishing a new home. Okay? But perpetrators are also eligible for crisis payment because they may have left the house and be unable to return. So they also can fit these definitions. So you need to realise and remember that perpetrators can also get crisis payment. Okay. There is situations where there's family and domestic violence where crisis payment is not payable. So it might be that the perpetrator is someone who doesn't live with them. So there might be an ADVO out and they're excluded from the house, but they never lived there in the first place. It might be that the daughter's boyfriend, who sometimes stays overnight, is the perpetrator, but they don't live there. Okay. So it might be that the victim's income and assets is over the threshold, so they're not eligible for job seeker or parenting payment. They can't get that primary payment, so therefore they can't get the crisis payment. Or the contact was too late. They didn't contact within 7 days. So there are situations where you just can't get it even when there's family and domestic violence. Okay. So one of the other payments that you might want to look at is urgent payment. Now, this isn't actually a separate payment, so you need to be really, really aware and really careful when you're applying for this one, because this is an advance on your payments, and your next payment is going to be lower because you got an urgent payment. So you can get an installation of your current Centrelink payment paid and earlier than you would normally get it, and then you receive money next time. You can get it twice in 12 months. You can get it if you're experiencing severe financial hardship due to family and domestic violence, and you might be able to get it more than twice in some circumstances, limited circumstances. It's just popping online to the Centrelink Express Post app or onto MyGov, or ringing up on the phone and applying in those sorts of ways. All right. So, any questions?
Okay, so yes, we have a few questions. Okay, if you are using the disbursement method, do you need to report every time you receive child support, or does child support report what is paid each time? Does that make sense?
It makes complete and utter sense, but to tell you the truth, I don't know off the top of my head at all.
Okay.
Yeah, it's a look. I really wish I did. I wish I could answer all these questions as they're asked. Unfortunately, it's as you may be able to tell from the presentation, it's a really complicated area, and I can't memorize everything.
Okay. Sorry. Somebody has said that they were advised to be careful if your client's perpetrator is an authority on their Centrelink account. Have they found a resolution on how we can use Section 24 and have the perpetrator not be notified that they have been removed?
Do you know what? That's something I'd like to look into, because I didn't know. I would like to look into whether perpetrators. I don't know that I realised that perpetrators are notified when they're removed as authorities from people's Centrelink accounts. So I want to look into that. So obviously I can't answer the question because I didn't know that the premise existed in the first place. So I'm going to be looking into that, and if it is the case, then it's probably something that we need to talk to Economic Justice Australia about, to see if that is some advocacy they can do on our behalf to the government, to see if something can be done.
Could I just mention something here, Donna?
Yeah.
So when you do have a perpetrator who has access to your Centrelink account, when you actually end that arrangement, they do get that notification. But if you do have a concern that your client is experiencing family or domestic violence, you can actually contact Centrelink and let them know that that's the situation prior to ending that arrangement.
And does that mean that Centrelink will then not contact the perpetrator and will not contact them, not notify them, or not?
I'm assuming so, that's what they say on the website. I'll pop a link in the chat to that, but that's obviously something that we need to look at further.
Okay. If a person is not receiving the amount of child support that that it has been said that they're supposed to be receiving, how can they prove this to Centrelink to have family tax benefit reassessed in their favour?
So if you have been assessed as receiving a certain amount and you're not receiving that, and your family tax benefit has been dropped because of the income that Centrelink is assuming that you're getting because of that child support, then what you need to do is have the child support collected by the child support agency and asked to be assessed on the disbursement method rather than on the entitlement method. If you think that you've been assessed at the wrong amount and that actually you should be assessed as that your ex should be paying a lesser amount, then you can talk to legal aid and see if it's possible for the child support to be reassessed and dropped. But if it's been pegged at the right amount and you're not receiving it, then the only way that your family tax benefit can be adjusted so that you're being paid family tax benefit based on what's actually going into your bank account is if you get the child support agency to collect the child support and you ask to have your family tax benefit paid on the disbursement method rather than the entitlement method.
Does Centrelink require evidence for when the victim survivor decides to leave? And if so, what? What evidence?
So, yeah. social workers will do all of the assessments. Sometimes sometimes it's just a conversation, with the person, but I suspect it'd be pretty rare that it is. But the decisions can be made on conversations with refuges, with support workers at refuges. It's the same sort of evidence that we've talked about before. It might be evidence of applying for rental accommodations. It might be evidence of actually entering a refuge and having them say, no, this is a long-term proposition, and we're assisting them to find permanent accommodation elsewhere. It's pretty nebulous. It's whatever you can get. But it's, once again, it's the social workers that make those assessments as to whether they believe it's a permanent removal. So we had one client who was refused crisis payment when the ex was removed from the home, because they told the social worker that once they were released from jail, they'll be coming back to the house because there was nowhere else that they could live. So they were refused crisis payment because the perpetrator hadn't left permanently. So, but it's the social worker making those assessments based on those conversations.
Okay, so what is the age of children when child support is not mandatory?
I don't know. I don't know child support.
Okay.
I'm so sorry. I'm a social security lawyer, not a child support lawyer. I've never practiced it.
Okay, there's a question about the social workers, Centrelink social workers. Should we do that now? Yep.
I might say we're discussing it at the end, but we'll ask it anyway.
Well, it's the last question I have, so if everybody wants to put more in the chat. How did services get in contact with local Centrelink social workers? Is there a method?
It's later on in the...
Yep. Okay.
Yeah. Brilliant. All right. So now we're talking about residency. Okay. So, which is the residency of Australia, not the home that you live in. Yep. So in order to get a Centrelink payment, you need to be a permanent resident or Australian citizen. There's some rare and limited circumstances where you might be able to get a payment when you're not a permanent resident. But as a general rule, you have to be a permanent resident or an Australian citizen. But if you are newly arrived in Australia, then there's a waiting period. People aren't eligible for a payment the moment that they arrive, even if they arrive on a permanent residency visa. So those waiting periods generally start on the day you arrive, or if you got your permanent residency after being in Australia, then those waiting periods start on the date that you got that permanent residency visa. So whichever is later, yeah. And that waiting period applies to most payments. So it's 4 years as a general rule. So all of those income support payments, that job seeker, parenting payment, youth allowance, Austudy special benefit, all of those income support payments, it's 4 years. For payments that recognise the care you're providing another person other than parenting payment, it's 2 years for carer payment, parental leave pay, and dad and partner pay. It's 1 year for carer allowance, that's supplementary payment. It's 1 year for family tax benefit Part A, and the only payment that is granted immediately on getting that permanent residency visa is family tax benefit Part B. Now, the waiting period is even longer for age pension and the disability support pension. So you need to have lived in Australia as a qualifying resident for 10 years before you can get the DSP and the age pension. Now, we're not going to go into qualifying residence period today. If you want to know more about I talked more about qualifying residence in our disability support pension session. And if you have people that are facing that 10-year waiting period, then you can send them to us for advice. But there's hope. There are exemptions to that waiting period. So if you have a client who's a newly arrived resident who has been told, don't bother lodging an application, or lodged an application and been rejected because they haven't been in Australia long enough, it doesn't end there. there are exceptions to those waiting periods. So one of them is if you are a spouse or a dependent child of someone who entered Australia as a refugee on a protection visa, then you might be eligible for an exemption from that waiting period, and you might be eligible for a payment on the day that you arrive in Australia. If you became a single parent after becoming an Australian resident, then you might be eligible for the lone parent exemption and might then have access to parenting payment, single, job seeker and youth allowance. Or if there was a significant change in your circumstances, then you might be eligible for the payment called special benefit. So significant change in circumstances only gets you access to one particular payment. But it's a really important one to know about. So special benefit has that 4-year waiting period. If you are a permanent resident, you've experienced a significant change in your circumstances that was beyond your control, and you are experiencing financial hardship, then you might be able to get access to special benefit. The change, that significant change in your circumstances, has to have happened after you got your permanent residency, and it has to have happened after arriving in Australia. So your significant change of circumstances can't have happened after you got your permanent residency in your birth country and before you arrived. Significant change in circumstances can't have happened after you arrive in Australia on a temporary visa and before you get your permanent residency, unless there's family and domestic violence. Okay, so if you experienced family and domestic violence and that is the cause of the significant change in your circumstances, then that significant change can have happened in Australia and before you got your permanent residency. So relationship breakdown, moving house, unable to work, all of those sorts of things, issues with your health, all those issues, significant changes in your circumstances that change how you're able to support yourself and or your children, those things can give you eligibility for special benefit before that 4-year waiting period expires. Okay. So we had a client who arrived in Australia and met her future partner. They moved in together, got pregnant, had a daughter, and then Mike became increasingly controlling and violent. And on the day that Zena got her permanent residency, he threatened to harm their daughter. So she wanted to leave, but she had no idea how she could get any income. She didn't know how she'd be able to care for a child. She couldn't leave the relationship because she had absolutely no access to any finances, nowhere to live. She contacted us 18 months after she'd been a permanent resident. So she was 18 months through her 4 years newly arrived residence waiting period. She was a permanent resident. So the legal options available to her were immediately she could access family tax benefit A and B and childcare subsidy. However, she was in a relationship, and so Centrelink were going to want to know husband's income and assets. And if he was trying to control her access to finances, then merely making that application was potentially going to be quite dangerous to her. Now, since we actually advised and assisted Zena, those changes to Section 24 have come in. So now if she was to come to us, we would potentially talk to her about asking Centrelink for a recognition through Section 24 that even though she's in a relationship, she accepts she's in a relationship, she declares she's in a relationship, because of the family and domestic violence, she'd like to be treated as though she was single. If that application was successful, she'd potentially be able to apply for family tax benefit, childcare subsidy and parenting payment or special benefit before she left the house and would have financial support before she left the house. So the changes to Section 24 didn't exist when we were assisting Zena, and so that wasn't something we talked to her about. But she got, we helped her get in contact with a refuge. She eventually left the house. And when we were talking to her about what her eligibility would be when she left the house. So when she left the house, she was able to apply for parenting payment because she was a permanent resident when her relationship ended and she became a single parent. So she was eligible for that lone parent exemption. Okay. She was also able to apply for crisis payment because as long as she'd applied for parenting payment, she can also apply for crisis payment because she'd left the house and was unable to return. We also recommended that she lodge an application for special benefit as well as parenting payment. You can't get them both at the same time, but we suggested she apply for both so that if one was rejected, the other one maybe she might get the other one instead, because there'd been a significant change in her circumstances that was beyond her control and that involved domestic violence. So she should be eligible for that exemption from the 4-year waiting period for special benefit. So another thing that she, should consider and that can be considered is whether children might be eligible for a payment even when the parent is not. So the parent might not be eligible for a payment because because of their residency, they might be a New Zealand citizen, they might be a temporary resident and not have a permanent residency visa, but the child might be an Australian citizen or might be a permanent resident. And if that's the case, if the parent is completely ineligible for a Centrelink payment, but the child is, then the child can apply for and be granted special benefit, and the money will be put into the parent's account. Okay, and there's all sorts of other aspects to this, but that money is paid to the parent until something intervenes or things change. Okay, so that money is paid to the parent until the child becomes independent or until they can get youth allowance. And as I said, there's a whole load of different aspects to it. So there's all sorts of different things depending on how old the child is, depending on where they're living, enrolment in education, all sorts of things. And as soon as that parent becomes eligible for a payment in their own right, as soon as they become a permanent resident, then the special benefit stops. And the parent has to lodge an application for a payment themselves.
Welfare Rights Centre, this is Julius.
Hi, I'm ringing because I've got a bit of a problem at the moment. I've just had to leave my house with my 4-month-old daughter and I don't have any money. I can't afford food. I can't afford rent.
I'm so sorry to hear that. It sounds like you're in a really difficult situation. When did you leave your home?
It was about a month ago. My ex-partner was violent and abusive. I couldn't stand it anymore.
Okay. And how have you been supporting yourself since then?
Just of charities and the refuge I'm staying in at the moment.
Have you tried applying for any Centrelink payments?
Yes, I did. I applied for parenting payment, family tax benefit, but I was knocked back.
Okay. And when was it rejected?
I think it was sometime last week. I can't remember what day.
Did Centrelink say why they rejected it?
They said it was because I'm not an Australian resident. I applied for permanent residency, but I haven't got it yet.
All right. And do you know the name of the visa that you applied for?
Yes, I applied for the 820 partner visa a few months ago, but I haven't heard anything back yet.
All right. And what visa are you on at the moment?
I'm on a bridging visa A.
Okay. So you mentioned earlier that you fled your home with your daughter. Is she an Australian citizen?
Yes, she is, because her dad is a citizen.
All right. I think it'd be useful to book you in to speak to one of our solicitors. There's no charge. We're a free service. Would you like me to go ahead and do that?
Yes, please. Do you think you can help me?
I'll need the solicitor to look at everything properly. I'm not sure if we can get you one payment, but there's at least a chance that your daughter might be eligible for a payment. This matter is obviously urgent, so I can book you an appointment next Tuesday. Can I double check that you're able to stay in refuge till then?
So thinking about that particular situation, they're a single parent to a child, they're living in a refuge, they're homeless, they're in severe financial hardship, and the mum is on a bridging visa A. She's applied for permanent residency, but it's not been granted, but the daughter is an Australian citizen. So thinking about social security eligibility and Centrelink payments, bridging visa A, she's not eligible for any social security payments at all. There's no social security payments that she can access. That relationship breakdown happened before she became a permanent resident. So even after she gets her permanent residency, she's not going to be eligible for that lone parent exemption, that access to parenting payment, because the relationship breakdown, she became a single parent before she became a permanent resident. But the relationship broke down because of family and domestic violence. So even though that significant change in her circumstances happened before becoming a permanent resident, she might be eligible for special benefit after she gets the new visa. Not now, but after she gets the new visa. And in the meantime, because her daughter is an Australian citizen, her daughter can apply for special benefit. And as long as they pass any income and asset test, then the daughter will get the payment. The money will go into the mum's account. The moment that she becomes a permanent resident, she can lodge an application for special benefit in her own right. The daughter's payment will stop and the mum will start getting that special benefit payment in her own name instead. So, any questions?
Hi. Yes. Okay, so if the client is the client eligible for special benefits if she is on a bridging visa and has applied for a protection or partner visa and has a child in her care who is an Australian citizen? I believe you said before that the child may be eligible for the special benefit.
I think that's exactly the scenario we just had there. So hopefully that scenario answered your question.
Okay. So yeah, there's two questions about that are basically the same. Does the 4-year waiting period after receiving permanent residency still apply even if somebody gets citizenship within that 4 years, or do they become eligible for Centrelink after gaining citizenship?
No, you get, once you become a citizen, you're eligible for payments, but it doesn't defeat the qualifying residence period. So becoming a citizen won't mean that you get access to age pension or DSP. That 10-year qualifying residence period will still exist, but if you become an Australian citizen, you'll get access to the other payments. That newly arrived residence waiting period will no longer exist.
For a woman who is not receiving any Centrelink benefits while she is with her partner and is considering leaving him, would you advise that she applies for parenting payment and crisis support now before she leaves, or do the benefits then do they start when she leaves? Yeah, would it be better to apply before you leave?
I think it's way too fact specific. Like I wouldn't be able to answer that as a general sort of thing.
Okay.
But I have to say, crisis payment you can only get if you have left the home and you're unable to return, or if the perpetrator has been removed from the home and is unable to return. You cannot get crisis payment when you're still living in the home and thinking about whether you might want to leave.
Okay. If a we do have to keep these broad, just so everybody knows. There's a lot of very specific questions coming up. If the mum is a New Zealand citizen and their child is an Australian citizen, and the mother is the primary carer, can she claim the family tax benefit and the special benefit after separation?
So New Zealand citizens and what eligibility they have for payments, it's a topic all on its own, and we're doing a session on newly arrived residents and Centrelink in December. It's a 2-hour session all on its own. You get to watch me talk to you again for 2 hours. I'll be running that in December, and you're welcome to come to that. I have to admit I've sort of lost now the rest of the question. So it might depend on what there are some payments that New Zealand citizens can get that acknowledge care of children. There's some payments they can't. I think it might be a bit big and messy to answer.
I guess it was basically if the parent is from New Zealand and the child is Australian, can they get family tax benefit and the special benefit? Yeah.
So many times that I tell clients, test your eligibility. Lodge an application, test your eligibility. If it's rejected, come to us, appeal it. But if the parent is on family tax benefit, then and the child is an Australian citizen, I'd be going, lodge an application, test your eligibility.
Okay, so there's 20 minutes to go, so we should probably keep going.
Okay, so debts. Common reasons why you might get a debt from Centrelink because when there's been family and domestic violence. You'll often find that the victim survivors can be lumbered with really significant debts due to the actions of the perpetrator. Perpetrator might lie about their income, they might hide the assets, they might steal money, so lump sum payments and things like that from the victim survivors. They might be forcing them to hide relationships and lie to Centrelink, and then those situations where the kids aren't returned after the visitation. Okay. They can also be paid single when they're in a relationship, that loss and change of care, and there's also a risk of prosecution for Social Security fraud. So this is what a debt notice looks like. You'll find there's the amount owed up the top there. As you can see, this one is specifically that someone was overpaid their disability support pension because Centrelink decided that they were a member of a couple when they'd been paid as a single person, and they've gone back to 2004. So it is a 15-year long debt. It's a 15-year debt period, and they got a $64,000 debt. So Centrelink can go a long way back in time when looking at whether you're in a relationship or not, when you're being paid as a single person. Okay. So if you have a client who has a debt, you've got to contact Centrelink and make payment arrangements within 28 days of getting the debt, or they risk interest being charged on their debt. If they don't enter a repayment plan and they're on a Centrelink payment, then they're going to have 15% of their Centrelink payment automatically deducted. So they need to call and request a lower amount and a lower repayment amount, because otherwise they're losing 15%. And Centrelink can get a garnishee order. Okay, so repaying a debt doesn't admit liability. It doesn't say it's correct. It doesn't say that you owe it. You're still going to have the right to appeal, but what it does is it stops interest being charged. Yeah. And entering that repayment plan means that you get more control over how much you're repaying. Okay. But don't ever appeal the debt without getting advice, because debts can go up on appeal. It's not uncommon for us to have people come to us going, I had a $1,000 debt, I appealed it, they now say I owe $15,000. Can you help me? And that's not uncommon. Okay, so get advice. If you have someone who has a debt, get advice. Okay. It's also, perpetrators know things. They know about the Centrelink rules and they use them. So one of the rules that they know is that if you're in a relationship, both parties' income is taken into account for family tax benefit, and you must do a tax return within 12 months of the end of the financial year. And if both parties don't do their tax return or say they don't have to within 12 months, then every cent of family tax benefit that you received is recalled as a debt. So perpetrators will leave, the relationship will end, and perpetrators won't do their tax return knowing that their ex will get a debt. Okay. Now, it's possible to have those debts where that relationship has ended and it's the ex's actions, it's the ex not doing their tax return that's caused the debt. It's possible to have those debts written off. So have a chat to Centrelink and ask for that debt to be written off when it's due to the ex's non-lodging of their tax return. If it's for anything else, don't talk to us first. Talk to us first in this situation as well, if you like, just to be on the safe side. But it's possible to get those written off. Now, if you've received a debt, if you've received more money than you're entitled to, then it is also possible to get those debts waived, even when you should never have received the money in the first place. And that's due to when there's special circumstances. They consider special circumstances. So it's where you didn't behave in any way knowing that you are going to get more money than you're entitled to, and you have particular special circumstances that are unusual, that are different, that mean that it would be the just decision to not require you to repay that debt. And domestic violence can be taken into account as a special circumstance. So it's looking at the experience of the victim. It's not necessarily, it doesn't have to be domestic violence during the debt period. It can be previous relationships, circumstances in their childhood. It can be looking at the loss of custody because of the actions of a perpetrator. It can be looked at evidence that they shouldn't be treated as a member of a couple. It can be, it's all sorts of different things, but it's that family and domestic violence can be considered. Okay. So we have, look, I think we're okay for time. So we have a person who was married to a husband for 10 years, worked as a sales assistant. The husband was very violent, very controlling, managed all the finances, handled all the Centrelink correspondence, never let her do anything. She never talked to Centrelink, never updated Centrelink, never did anything at all. She eventually left. She didn't understand how Centrelink or any of it worked at all. She was supported by a refuge to get access to payments and to get a private rental. She started getting the life back on track, and then she's notified by Centrelink that she has these debts dating back to when she was with her husband. And while talking to us, it was clear that a whole load of different services had contacted her, but she had no idea what they wanted, what was going on, and she was really, really struggling to understand what was happening, pay the bills and rent. So we asked that her fortnightly repayments be reduced, and we got a Freedom of Information request in to try and get a hold of her Centrelink file to try and work out why the debt existed in the first place, what on earth was going on, how it came about. And we realised that the debt came about because of the actions of her husband. The husband was undeclaring his income, and when Centrelink data matched with the ATO, they realised that that discrepancy was there. So an appeal was lodged to an authorised review officer and a request that special circumstances be considered, because she be considered in order to get the debt waived. So one of the things that where Section 24 can be considered as well, not only in looking at what rates of payments you might get and what the payment you might have access to, but it can also be considered in appeals of debts. So if you have received a debt because of a relationship, then you can ask that Section 24 be applied retrospectively and in the past, saying that I was in a relationship, that relationship existed. I was a member of a couple for Social Security purposes, but I would like you to consider Section 24 and treat me as though I was single during that past period, even though I was in relationship, and I would like you to recalculate my debt based on me being single, even though I was in a relationship. And so in that situation, she might have been able to ask that Section 24 be applied to that period of time when she was with her husband and the husband was under declaring his income, so that then the debt is calculated and his income and he is completely ignored and the debt gets recalculated as though she was single. Okay. So appealing Centrelink decisions. All right, you can appeal most Centrelink decisions, but not all Centrelink decisions should be appealed because debts can increase and people can be prosecuted. There are time limits to lodging appeals depending on whether you are doing an internal appeal to an authorised review officer or an external appeal to the Administrative Review Tribunal. It used to be known as the Administrative Appeals Tribunal, but it has now changed. It's now the Administrative Review Tribunal. Debts have no time limit to appeal, so you've got time to get advice beforehand. Okay, so accessing support to get Centrelink payments. So this is keeping your information safe. Clients can go use MyGov or call Centrelink to update their passwords and change who can access accounts. So who can talk about your accounts, who they can talk to about accounts, your nominees and things like that. And you should always contact Centrelink and change those passwords, change who has access before updating bank account details, before updating relationship status, before updating addresses and phone numbers in order to keep your clients safe. As we've already mentioned, as Alentia has already mentioned, talking to Centrelink will hopefully mean that the perpetrator isn't informed that they have been removed and that that's what this website implies, but you probably need to talk to Centrelink about that first. Access to social workers. So it's difficult to get. I know people want to know how to access them. We can't, there's no magic trick. We can't give you some nice secret back sort of way in order to get an access to a social worker. Mentioning domestic violence is supposed to get you faster access to social workers. Calling any Centrelink number should get, and saying that you need a social worker should get you access to a social worker. They're not in every office full time, and it's usually only phone support that you will get, and you usually have to wait a few days. And it is one of those things that if you feel like doing advocacy to your local MP, to any of to federal MPs, to say that more access to social workers is needed, then I would encourage you to do that. So there's other financial support that people may have access to as well if they are experiencing family and domestic violence. So there is the Family and Domestic Violence Financial Assistance Payment through the Red Cross for people on temporary visas, and it's $5,000. It used to be $3,000, it's increased. Then there's the Escaping Violence Payment administered through the Wesley Mission, and then there's the $5,000 Immediate Needs Support Package through Victims Services.
So these are just some contacts which are First Nations Domestic and Family Violence Services. First Nations Women Legal, they do some outreach located throughout Sydney. You can actually go online and see where those clinics are being held if you have a client that needs to have some legal advice. Baringa Via is a statewide gender-specific service, so that is for Aboriginal women and children. They offer legal advice, court support, and they also run outreach clinics. Mudgingale is located in Chippendale. They're a community organisation. They're also a women's place. They also do outreach clinics where you can go there and get legal support. They do that. They run that in partnership with Redfern Legal Centre. In terms of accessing Centrelink social workers for First Nations organisations, I've found that having contacts with Indigenous community engagement officers can assist with accessing Centrelink social workers, and also calling the Indigenous call centre that way and asking to speak to a social worker. Some community workers have said that that could be faster. And then we just have Aboriginal Legal Services and Family. I will also pop links to each of those services' website in the chat. We just go to the next slide. So this is just a snippet from our dedicated First Nations access section on our website. This fact sheet in particular is Am I really in a relationship? So that goes back to the member of a couple stuff that Donna talked about earlier. If you have a client and you're not sure where to start, these fact sheets are really useful, and there's actually other topics on the website that you can access as well. Next slide. So there are other community legal centre experts who offer specialist services to victims of domestic and family violence. So Women's Legal, which was in that previous slide, they're a specialist and they have a First Nations outreach program, which I've already just mentioned. Mob Strong and Financial Rights. So financial rights can help with people that have problems that are relevant to financial abuse. They also have a First Nations unit called Mob Strong. Yep. And then again, we have Redfern Legal Centre that works closely with both Warringah Buyer and Mudgingale, and they do hold outreach clinics as well.
So Redfern Legal Centre also have a domestic violence and family abuse service. It's one of the only free services in existence that will help people who are where it's an intimate partner relationship, they're going through family law proceedings, and there's a property settlement, and it's one of the only times that you will get legal advice and assistance and potential representation for a property settlement in family law, and it's only where there's intimate partner violence involved in that relationship. So any questions? This is the end. We've reached the end. Is there any final questions?
There actually, can clients on a student visa experiencing family and domestic violence apply for the Red Cross temporary visa payment? Do you happen to know?
I don't know. Unfortunately, I don't. Those are just aware that those payments exist, and because they're not Social Security payments, I don't know anything about them.
I did put the links in the chat for those.
Lovely.
And Alentia, somebody did ask if maybe you could add in some of those links. That would be brilliant.
Yeah, doing it now.
Okay, we've got 4 minutes left, so should probably do the last few slides.
Okay.
If you're in New South Wales and have a problem with Centrelink, our client intake line is open every Monday and Wednesday from 9:30 a.m. till 12:30 p.m. The numbers are on the screen. And you can also contact us anytime through our website or via email. Registrations are now open on our website for our upcoming Carers and Centrelink webinar, which is running in November. We will have the Migrants and Centrelink registrations open very soon as well. Please follow us on Facebook, Instagram, and LinkedIn for regular Welfare Rights Centre updates, along with Centrelink tips and educational information. So we'd really appreciate it if you could please take 5 minutes to complete our evaluation survey. Your feedback helps us to improve and also to secure funding so we can continue providing free webinars, just like the one you've attended today. I also set up an email, so it should have gone into your inbox basically right now that has the link and the QR code in it. We hope that you enjoyed the session today, and we look forward to seeing you at future events. Thank you, Donna. Thank you, Alentia.